let them go. Okay, everybody. We've almost got this down to a science. However, okay, please don't interrupt me talking. Please, please, please don't interrupt me talking. Don't talk over one another. You're going to make the court reporter mad. So if her camera comes on, Ms. Richardson's camera comes on and she throws her hands up, that means y'all are talking all over one another and she can't take down what you say. All right? Call the defendant's name. I'm going to hear from pretrial, defense attorney, then the state. Real simple. Please be aware, I do read everything. So this is here for bond hearing. Bond hearing. It's not a prelim, everyone. Okay? So make sure, let's see. They're not in caveat. What we'll start with, we'll do the people that are in custody first, and then we will take care of the folks that are just here for bond modification that aren't in custody. All right, let's see. See what lawyers we got here. Do we have a lawyer for Jermaine Watts?
Yes, Your Honor.
All right, Madam Court Reporter, you ready?
Yes, Judge, thank you.
All right, Bostic, you ready?
Yes.
And what about Ms. Holmes? You ready?
Yes, Judge.
All right, we got all the important people. All right, this is going to be, now it could have changed the numbers on the counter, but just bear with me, everybody. We got the state, right? Ms. Porter, Ms. Porter.
Yes,
Saw her. Okay, here we go. So it'll be position 2 on my counter. Like I said, it could have changed. If it did, that's okay. All right, position 2. And we got 22 CP 211328. Let's see, 97 days without indictment. Jermaine Derek Watts, loitering and prowling, willful obstruction of law enforcement officer, theft by receiving stolen property. There's an $18,000 good bond as of August the 10th, 2022. Trial.
Judge, in regards to Mr. Watts, 24 prior arrests. He has an open case, 22 CP 212425. Another open case, it's like 5 CWAC charges of various degrees assigned to Judge Lethbridge, 19 SC 167493. He took a first offender in 2016 on a burglary. Other convictions are misdemeanors. 2014 simple assault, 2017 theft by shoplifting. Nothing further.
All right. All right, who's here for Mr. Watts?
I'm here, Your Honor, here on behalf of Arnold Vegas. Your Honor, we'll ask that Mr. Watts be given a reasonable bond. He is indigent, and it is past 90 days. He was arrested on 9th, 2022. So, Your Honor, I did hear his history and his other pending charges, but we will ask respectfully, Your Honor, if he would have a reasonable bond set on this case.
Do you know where he's going to be living, counsel?
I haven't had a chance to get that information from him, Your Honor.
Mr. Watts, you going to be living in Fulton County? Thumbs up or thumbs down? Mr. Watts, Jermaine Watts. Jermaine Watts, wave your hand.
Your Honor, he's going to be the last one on the calendar. They got several gentlemen that's going to be before you, so he's going to be the last one.
Well, good job, Ms. Roberts. We'll try it again. All right, let's see. Let's take the folks in. All right, we got Corliss Calloway. Is the attorney here for Corliss Calloway? All right, Xavier Harvey's lawyer. Are you here?
Yes, Judge, I am.
All right, Mr. Lewis. Mr. Harvey, wave your hand. All right, best you can. All right, I see you got your handcuff there. All right, it's position 13, 144 days without indictment, 22 CP 210140. Xavier Harvey, 144 days without indictment, possession of controlled substance, schedule 1 or 2, ecstasy, and possession of marijuana with intent to distribute. That was 2.52 ounces of marijuana and 17.5 grams of ecstasy. We need his, sir, you gonna be living in Mississippi? Thumbs up or thumbs down? Thumbs down. All right. Go ahead, pre-trial.
Judge, in regards to Mr. Harvey, 6 prior arrests. felony reduced to a misdemeanor, is convicted in 2020, carrying a concealed weapon, carrying a weapon without a valid license, took a first offender in 2019, marijuana with intent Schedule 2 with intent Schedule 5. One arrest for probation violation, nothing further.
He's on a ISP pretrial. Was he supposed to get that, or was that something somebody forced upon pretrial?
I'm sure it was one of those statements given some type of supervision. But yeah.
Gotcha. All right. Go ahead, Mr. Lewis.
Judge, the most relevant thing here is that he is beyond the 90 days. He was due to get indicted within the 90 days. At least that's what the Georgia law says. I'm not, since I see your prosecutor and I haven't had a chance to beat her about the head and face with this law, I'm gonna leave it alone right now and say that we'd ask the court to change that 15,000 down to a UJR. If you can't get to a UJR, get it so low it doesn't matter. The ISP on the second part, that UJR is fine where it is. And also have the address updated by the defendant within 24 hours of release since you're still looking at the Mississippi address. Thank you.
All right. What says the state?
Good afternoon, Your Honor. This defendant did have a bond modification on June 2nd of this year. This is a reasonable bond, 15,000 in UJR, considering the amount of drugs that were recovered and his history. The state believes that this bond should not be disturbed. It is reasonable.
All right.
Judge,
Yes, sir.
question, Judge. Did you you are still the judge that does the bond modifications, right?
Yes.
If anybody, okay, all right. I said that because it sounded like that was brand new news here. When is this man scheduled to go before the grand jury?
Ms. Porter?
I don't have that information before me. I don't
Okay.
know when he will be scheduled. I believe that there will be an ADA assigned to this case and the determination will be made.
All right. So, Judge, I'm not going to beat Ms. Porter up about this because I know she don't control it. But the net effect of what she's asking is that you continue to hold a person in jail on the bond that he has not been able to afford forever without indictment. So that's the reason why I'm asking for UGR. We didn't go through IALA because they did that at first appearance. But to hold a person forever without indictment, no plan to indict on any kind of bond is downright illegal. Thank you.
All right. Hold on one second. Tamara Abercrombie, take that screensaver off of your screen. Either turn your camera on or take that screensaver off. That is inappropriate. Very inappropriate. Do not put that back up there, ma'am, or I will remove you from this meeting. All right. Sir, are you going to live in Georgia? Are you going to live in Georgia? Just nod your head or shake your head. Not going. You going to live in Mississippi? I can't hear you. Just nod your head or shake your head. No, I can't hear. Okay. Well, all right. So there'll be no drugs unless prescribed, no alcohol, no weapons. Stay away from 3155 Camp Creek Parkway. Stay out of Fulton County unless you're here for court or to see your lawyer. You're going to have to update your address within 24 hours of being released. No further contact with Isaiah Gathright, G-A-T-H-R-I-T-E. 24 hours of being released, sir. Let's see. You've already got 15,000 on count one, so we'll make that 7. They didn't really want to take you through pretrial ISP.
You know what that's all about, Judge?
Judge,
You
what kind
figured
of
it out?
charges the ISP is on? Is it on a misdemeanor?
Possession of marijuana with intent to
Weed with
distribute.
intent. 2 ounces. 2 ounces of weed, allegedly.
1,000 on count 2. Got that, Ms. Holmes?
Yes, Judge.
All right. Best
I
of luck.
heard 7 and 1 to make 8, correct?
That's it. Best of luck to you, sir. You can leave the booth and call.
Nothing further, Judge. May I be excused?
Absolutely. Have a good week.
You as well, ma'am.
Did we ever figure out who's representing Mr. Calloway?
It's attorney Sean Hoover. I reached out to him and he was emailed the Zoom link.
Who? Can I ask who Sean Hoover is? Is he ARPD?
He works with the conflict defenders. And Your Honor, he asked if you can hold for his report. He's on his way to office to log in. He had
Okay.
Okay. So if he's actually going to do it, I'm gonna leave.
All right. Thank you.
Well, I don't know
Huh?
the case. what he's doing. I just know he has a couple of cases on his calendar. I'm not going to volunteer him. I don't know what case you're talking about he's handling.
We
Yeah,
just
you
want to make sure it's coming. Thank you, Mr. Lewis.
All
What
right,
about
thank you, Judge.
Thank you, Kamari Johnson. Who's representing Kamari Johnson? Are you here? Anyone representing Mr. Kamari Johnson?
Yes, Your Honor, I'm having a little Zoom trouble.
All right. Let's see. Position 6.
Attorney Eric Johnson, Your Honor, can you hear me?
I can hear you. Kamari Johnson, wave your hand. All right. Position 6, pretrial 22 CP 211409, 95 days without indictment. Right there, there is no bond. Got possession of a sawed-off shotgun, sawed-off rifle, machine gun, dangerous weapon, or silencer. Possession of a firearm during the commission of attempted to commit certain felonies, unlawful for a person employed by, associated with criminal street gang to participate in criminal street gang activity. Unlawful for a person employed by or associated with criminal street gang to conduct or participate in criminal street gang activity. One more time of unlawful for a person employed by or associated with criminal street gang or to conduct or participate in criminal street gang activity. Possession of marijuana with intent to distribute, seatbelt violation, and willful obstruction. Trial.
No prior arrest.
All right. Go ahead, Mr. Johnson.
Yes, Your Honor. Before you is Mr. Kamari Johnson. He is 20-year-old lifetime Atlanta resident. If released, he will be residing at 1939 Sandringham Drive with his mother, Miss Sherry Parks. Your Honor, as you read off the litany of charges in this case, there are no allegations of any violence in this case. This is more of a possession issue. My client was found in possession of the contraband that is alleged within the accusation in this particular case. So we would ask that he be given we provided a UJR in this particular matter. As indicated, this is his first arrest, Your Honor. And while the allegations may seem somewhat serious, and the fact that the allegation of street gang activity, he still enjoys the presumption of innocence at this particular time, because this matter has not been adjudicated as of yet. As stated, he has been in jail for over 90 days at the particular time. So, and this case has not been indicted, nor does it seem that there's any plans to indict it in a timely fashion. So we would ask that my client be given a $10,000 UJR for these charges, Your Honor.
All right. What says the state?
Thank you, Your Honor. ADA Siri Patel for the state. Your Honor, this case was a part of the Operation Heatwave that occurred this summer. And we asked that Your Honor I know we're above the 90 days at this point, so we're asking for $100,000 on the possession of the sawed-off shotgun, $100,000 on the possession of a firearm to commit a felony, $100,000 on each of the 1, 2, 3 gang charges, and then for $10,000 on the seatbelt violation and the marijuana. The defendant we'd ask that Your Honor find that the defendant is a flight risk. He was pulled over with a seatbelt violation. Him and the other occupant of his vehicle both jumped out and fled after being pulled over, abandoning the car. The defendant was found with a Glock switch, which is an illegal device. It is a very violent addition to a pistol that basically turns it into a gun that sprays everywhere. The defendant also has a jail incident from November 11th where he was involved in a violent act, and one of the inmates was given medical treatment for being punched above his eyebrow. As I said, this case was involved in the Operation Heatwave, and the defendant is specifically involved with the Playing for Keeps gang. He was observed dealing with other Playing for Keeps or PFK members and has a documented PFK history.
All right. No
Your
drugs.
Honor, Your Honor, if I may respond.
Okay.
Yes, Your Honor. First off, I'd like to point out that the $600,000 bond in this case will be $620,000 bond in this case will be very excessive for an individual who has never been arrested before. As stated by the state, my client was stopped for a seatbelt violation, was not for a violent crime. He fled the scene of that particular incident in which the contraband was found in the car. He was never alleged to be using the gang. And while the state alleges that my client has an extensive history with some alleged PFK gang, none of that history has resulted in any arrest prior to this point. So there's been no allegations of any violent acts on my client prior to this point. This is his first arrest ever in this particular situation. And this is basically a possession crime and him running from the police in this particular situation. So, Your Honor, we do not believe he has ties to the community. He is employed, Your Honor. He has worked at the airport in a material and packaging and handling for about the past 11 years. I mean, not 11 years, but the past 11 months, Your Honor. So he has ties to the community. He has no prior record where the state can allege that he's a threat to the community based on allegations that have not been proven in court at this present time. So we believe that he is and his case is over the 90-day period, so he's entitled to a bond. But we believe that a more reasonable bond than the $620,000 is laid out by the state would be appropriate in this case.
All right, gotcha. By the way, there was another warrant issued on August the 11th, 2022 for possession, purchase, manufacture, distribution, and sale of marijuana, just for your own information. No drugs unless prescribed, no alcohol, no weapons, no replica of weapons. Stay away from 490 Fairburn Road. Stay away from 320 Fairburn Road. Any PFK territory, and I think that's the area. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. You can only leave your house for court, lawyer, or to seek medical attention. He's going to live in Fulton County?
Yes, Your Honor. My question is, how would that curfew affect his employment? So is he not allowed to work during the pendency of the case?
You're going to have to talk to the state. That sounds like a him problem right now. No further contact with Stancer Crowder. No further contact with Christopher Ellis. No further contact with anyone related to, trying to initiated, associated with, playing for keeps, PFK. Anything else for the state as far as that? No social media?
No, that's it, Your Honor. And Mr. Johnson, if you want to give me a call, we can talk about it.
Will do, Ms. Patel.
All right. Let's see. Possession of assault shotgun, machine gun, dangerous weapon, or silencer, 50,000. Count 2. Possession of firearm during the commission of a felony, 20,000. Count 3, 100,000. Count 4, 100,000. Count 5, 100,000. Count 6, 5,000. Count 7, 500. And count 8, 5,000. Got that, Ms. Holmes? 50,000, 20,000, 100,000, 100,000, 100,000, 5,000, 500, and 5,000. Best of luck to you, sir. You can leave the booth.
So,
all right, let's see. Positions.
So that's the total of what, Your Honor? I'm sorry.
I don't do the math. I just rattled off the numbers.
So you said 50, 20, 100, 100, 100, 5,000, and what?
Okay, everybody. When I call numbers, please write them down. We gotta keep going. Nobody wants to be here all night. All right.
Sorry, I wrote down most of them. I just didn't.
All right, 50,000, 20,000, 100,000, 100,000, 100,000, 5,000, 500, and 5,000. All right, let's see. Malik Corbett. You can be excused, Mr. Johnson, if you're finished.
Thank you.
Malik Corbett, wave your hand. All right, is the attorney for Malik Corbett here?
Good afternoon, Judge. Sandra Fuller for Mr. Corbett.
Gotcha. Position 7, pretrial 22 CP 211439. Malik Corbett, 94 days without indictment. No bond as of August the 13th on aggravated stalking and an interference with government property. Misdemeanor. Trial.
Judge, in regards to Mr. Corbett, 4 arrests in Tennessee, 8 in Georgia. He has 3 convictions for simple battery. He has an open case in DeKalb for aggravated assault with a deadly weapon, 2 counts D02877249. Nothing further.
All right. Go ahead, Ms. Fuller.
Judge, we're asking for UJR bond. This case came out of a custody dispute, Judge, where Mr. Corbett had custody of his child. There was no violence in this case, no arrest leading out of this case. This was a violation of a restraining order where Mr. Corbett was trying to see his son per a court order, and the mom who lives in Michigan showed up at the house, blocked him in, and caused this arrest. Judge, he has not had any contact with her. In fact, there was a hearing held in Cobb County just a few days ago where the guardian ad litem would have stated on the record, it is in the order, that she would have given Mr. Corbett custody of his minor child had he not been in custody. So the only contact he has or reason to have contact is with the mother of his child, is this child that he has stepped up to the plate to support and provide. He's always worked, always provided for his child, Judge. And at some point when this case came about, he did have custody of the child. We're asking the court to award him a bond, UJR bond of $5,000, Judge. He will show up for court. He is a longtime resident of Georgia. He is not a flight risk. He is not a danger to society. And we believe that, Judge, if you granted him a bond, he will show up for court and that he will be living in Decatur with his grandmother, Judge.
What says the state?
Your Honor, the state's information, this case was presented to the grand jury today.
Okay, was there a true bill?
One moment. Your
What's
Honor.
his name, Judge? I'm sorry, which one was this again?
Malik Corbett.
Give me just a second.
One moment, Your Honor.
I've tried to open the attachment. It's just spinning for me.
Yes, it's indicted, Judge.
All right. Well, he has to stay in no bond status, Ms. Fuller. Do you know who's it assigned to, Boston?
It doesn't say right now.
All right. Do you have, has it got the SC number on there or not?
No,
All right.
it has the DA number though.
All right. All right, Ms. Fuller, it's been indicted. Mr. Corbett, you could go ahead and leave the booth. Your lawyer will have to get in touch with the DA's office, figure out what exactly it was indicted on, get that number, and she can get back in touch with you. You can leave the booth, sir.
Thank you, Judge. May I be excused?
Yes, ma'am. We have Christian James's lawyer here. Christian James's lawyer.
Yes, Your Honor, this is Ricky Richardson. How are you this afternoon?
All right, doing well. Position 8, Christian James, wave your hand. There you go. Position 8, pretrial Christian James, 22 CP 211397, 96 days without indictment, criminal damage to property second degree ×2, cruelty in the first ×2, battery substantial harm. As of August the 12th, there is no bond status. Trial.
Judge, in regards to Christian James, first offender on a burglary in 2016, couple of open cases, 21 CP 202790, aggravated assault, family violence, 22 CP 211408, aggravated assault, firearm by a first offender. Nothing further.
All right, Mr. Richardson, just so you know, there's some 1, 2, 3, 4 warrants outstanding. I don't know the date on them, just for your information. It's burglary, criminal trespass, willful obstruction, and giving false information. Go ahead with your argument, sir.
Yes, Judge. Mr. James is a lifelong resident of Metro Atlanta area. He will reside on Matt Williams Road, Southeast Atlanta 30315 with his mom. Prior to his arrest, he was employed with Taggart Temp Service doing warehouse work. He is a forklift operator. Judge, he attended South Atlanta High School, graduated in 2015. He's a father of one. Both of his parents are alive and present on the platform. His mom works as a administrative supervisor for a veterinary hospital in the Metro Atlanta area, and his father's a construction home improvement employer. He is not on parole. He has two brothers. He has one brother, one sister, two siblings who both live in the Metro Atlanta area. This incident is alleged to have occurred more than a year ago. He was arrested here in Atlanta without incident with the officers. If there is a warrant, it must be the 2016 case where he received first offender. He's always been compliant and reported, and I suppose they have put out the warrant as a result of this arrest. The other CP case is a fight that he had with his brother. Nothing more. The brother, in fact, has contacted the DA's office and provided a waiver of prosecution for prosecution. I don't think the state will ever be able to indict that case. He is on the platform if the court should have any questions for him. Judge, otherwise, we'd ask the court to say a good bond, an amount of $40,000 total, as the court deems appropriate in dividing it. That's all, Your Honor.
What says the state?
Yes, Your Honor. This defendant is entitled to a bond. However, considering the facts of the matter, there's video surveillance of the defendant pulling the victim out of a moving vehicle where there's two small children inside of that vehicle, causing that vehicle to strike another car and crashed into the gas station, as well as the open matters as aggravated assault case and a weapons case, Your Honor. This defendant poses a significant threat or danger to the victims and to property. This defendant also poses a significant risk of committing new felonies pending trial since he has open matters. So there is a significant risk of reoffending. For that reason, although the defendant is entitled to bond, the state would ask the court to apply a high bond. And Your Honor, the state would also ask for conditions being the stay away from the incident location, stay away from the no contact with the victims, no weapons, and any other conditions that you deem appropriate.
I didn't hear any numbers from you. Give me some numbers.
Your Honor, it is our practice that we don't give numbers. However, Your Honor, if you are looking for numbers, $75,000 for each count, which would be a total of $315,000.
May I respond, Judge?
I'm sorry, go ahead. Okay, briefly, yes.
Yeah, Judge. I mean, obviously, the Supreme Court has said numerous times, purpose of bond is to ensure a person's presence in court. He was here in Atlanta for an entire year before he was arrested. A bond is not supposed to be punitive. In this case, a $350,000 bond is tantamount to no bond. He has substantial ties to his community. His parents are here. His brothers and sisters are here. The alleged victim of the pending case is present. $350,000 bond won't do anything but punish him before there has been a final adjudication in the case. We asked the court to set a reasonable bond. The court said if the bond is going to be set, I think he's allowed to have a bond because it's been 96 days. It has to be a reasonable bond. A random $75,000, $350,000 bond without any rhyme or reason doesn't ensure his presence. Certainly the court can put special conditions like absolutely stay away from that location, absolutely have no contact with that individual, and GPS monitor to assure that. The money amount is just punitive, Judge, and he's not supposed to be punitive. He hasn't been adjudicated guilty. That's all, Your Honor.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Kendra McCritty, McCritty, no further contact with initials P as in Paul, M as in Mary, and T as in Tango, R as in, is it R? I can't. Is the other child's initials TR or is that TB?
TR.
Okay. No further contact with that child. If something comes up in juvenile court, then they can follow the juvenile court's orders as far as those children. Going to have stay away from 1401 Moreland Avenue, that BP Food Mart. You're going to have an ankle monitor paid for by the county with a 24-hour curfew except for court. Lawyer, does he have a job?
He does, Judge. He works for a temp service and his job is waiting for him as well as he works for his father, does full-time work for him. He's a framer as well as he does sheetrock and pours concrete.
So,
Father has several open jobs awaiting him right now.
Well, he can leave for work. However, he has to let the ankle monitoring company know and the state know what his schedule is, where he'll be working exactly, and proof that he has employment. I'm a 10,000 on count one, 10,000 on count two, 20,000 on each cruelty to children, and 15,000 on the battery substantial harm. Best of luck to you, sir. 10, 10, 20, 20, 15. Thank you.
Thank you, Judge. May I be excused?
Yes, Ms. Rockwell, you here? Not yet. Okay. What about let's see.
I'm here, Judge, but we might need to go last.
Okay. Natron Williams. Who's representing Natron Williams?
I am Judge Ricardo for Mr. Williams.
All right. Position one. Natron Williams, 22 CP 211572, 90 days without indictment. Armed robbery, possession of a firearm or a knife during the commission of certain felonies, and aggravated assault, no bond as of 8/18. Trial.
Judge, for prior arrest, no felony convictions. Conviction is a misdemeanor theft by shoplifting and misdemeanor possession.
All right. Go ahead, Ms. Mosby.
Thank you, Judge. Before the court is Mr. Natron Williams. He is 21 years old, Judge. He's pretty much lived here all of his life. His family moved here when he was 8 months old. He hasn't lived any place other than Georgia. As I said, he's 21. He's not gainfully employed. One of the things he's been working on while incarcerated is trying to get his GED worked out. However, when he and I talked, there's a path that he has to take and he has to enroll, and so he hasn't gotten that done. That's his number one objective, is to get the education done so he can get a real job. But I will say to the court, other than what was said He does have that shoplifting, which I believe was in 2017. He has no felonies. He has no reason to reoffend. I haven't really heard any facts from the state. Of course, I'm at the disadvantage of not having a lot of information at this point, but I understand there was another party involved. Whether or not that person has been apprehended, I don't know. I do know that he has been a member and been practicing the Muslim faith for about 2 years. And if granted a bond by this court judge, he will be staying on Madison Drive in Atlanta, Georgia. He'll be staying with his father. On the public access is a few of his family members, but I know his mother and father are listening. And so we would respectfully submit to the court that he doesn't know the actual victim of this allegation, so he wouldn't have a reason to intimidate them or have any contact with them. But if there was an order to stay away, that would be fine. He doesn't have a passport, and at 21 years old, he hasn't traveled very much. The most he's done is travel to go and see his brother in Alabama for college, and he went to Miami with his dad last June. Other than that, he doesn't travel much. He's not a flight risk. He won't intimidate any witnesses, and I will ask the court respectfully to give a reasonable bond given his age. He is not gainfully employed at this time. He does work part-time with his uncle, but that's sporadic at best. We will be asking for a $25,000 bond in total to cover all of the counts. Thank you, Judge.
What says the state?
Yes, Your Honor, this defendant is entitled to a bond. However, considering the facts of the case, the state believes that this defendant does pose a significant threat or danger to any person in the community. This defendant did use a firearm to take several items, including $500 in cash and $1,000 from the victim's Cash App, as well as the victim's phone and keys to his house and to his car. This incident was captured on video surveillance in which the defendant is seen on video with a firearm approaching the victim from behind. Your Honor, the state believes that the defendant does have a limited criminal history. However, the facts of this case is concerning to the district attorney and the community at large. The state also believes that this defendant can pose a significant risk of intimidating witnesses or otherwise obstructing the administration of justice based on the facts laid out in the warrant. The state would ask for a stay away from that incident location, which is Piedmont Park, no weapons, and any other conditions that you deem appropriate, such as a 24-hour curfew and ankle monitoring, and any other conditions that you deem appropriate. Thank you.
All right. Well, in this warrant there, Mr. Mosby, it says that the victim actually knew him.
Okay. And again, as
I they grew up in Clayton County together.
My information is limited at this point, so
okay, yeah. All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 1345 Piedmont Avenue. No further contact with Tremel, Tremel, Fitzhugh, Fitzhugh. No further contact with the alleged co-defendant, Willie Barfield, Barfield. Going to have an ankle monitor paid for by the county with a 24-hour curfew except for court. See your lawyer, seek medical attention. If he gets a job, Mr. Mosby, you can reach out to the state and we can amend it for leaving for employment. Let's see. I don't see where let's see. 25,000, 10,000, 25,000, 25,000, 10,000, 25,000. Best of luck to you, sir. You can leave the booth. Thank you, Mr. Mosby.
Thank you, Judge. Have a good evening.
You too. Rashawn Blue. Ms. Taylor?
Yes, Judge. I'm on.
Right.
I'm sorry. I'm in the back seat and I'm parked and stopped. I'm ready on Rashawn Blue.
All right. Just so you know, there's a warrant that was issued August 8th, 2022 for him for robbery. So he won't be getting out. Okay. It's position 5 pretrial 22 CP 21141.
Hold on. Judge, I'm sorry. That's the warrant in this case, isn't it?
I don't know. It just shows up that there's a warrant pending, Miss Taylor. 22.
Judge, that's all I know. That's the warrant in this case. That he was originally charged with robbery, Judge.
This warrant, Miss Taylor, this warrant was issued August the 9th, 2022. This one is still on there pending. So that's for you to work out with whomever. That's just giving you that information strictly for your information. Okay. All right. Position 5, 22 CP 211410, 96 days without indictment. robbery, no bond as of August the 12th. Trial.
No prior arrest.
All right, go ahead, Ms. Taylor Ayala.
Judge, that's exactly what I was just saying. This is
But
the
if I
same.
finish, Ms. Taylor, you gotta let me finish talking before you start talking. So go ahead with the Ayala on this case.
Okay, Judge. He is 18 years old. As the pretrial has indicated, this young man has never been arrested for anything. Lifelong resident of Atlanta and Georgia area. His parents moved to Ellenwood. He lives with his mother and father in Ellenwood, Georgia, on Catherine Village Drive. He was a senior in 12th grade in high school at Morrow High School. The allegations in this case are very spurious. Initially, Judge, is what I was trying to indicate. I don't know what else is showing, but he was charged with robbery. Then they changed it and put all these other charges. So it's not a separate warrant. It should not be a separate warrant. It's part of the same case. If you look at the dates should be the same.
Ms. Taylor, I can't see the physical warrant. I just see that there's a warrant that's flagged. Keep going on this case.
All right, Judge. So what I'm saying now, the Ayala factors, he has sufficient ties to the community. He is not any kind of flight risk, does not have the means to go anywhere. 18, still lives with the parents, was still in high school. Not a threat to continue committing crime, never committed any crimes, is still presumed innocent in this case, Judge. No allegation, even in the warrant, that he took anything from anybody. We have certainly in our investigation, we have a lot of doubts about this case. When Rashawn was arrested along with these other young men, Rashawn had $5 in his pocket. So obviously he hadn't taken anything from anybody. Just we believe he is entitled to a reasonable bond, not anything punitive. Has been in jail now more than the 90 days without being indicted. I would ask the court, it's not a UJR type of charge, but I would ask the court to consider a bond in the neighborhood of $15,000 to $20,000. This young man has no prior history at all, not a threat to anybody, and meets all of the Ayala factors, so he's entitled to a reasonable bond, Judge.
What says the state?
Yes, Your Honor. It is past 90 days, so this defendant is entitled to a bond. Considering the facts of the case, Your Honor, this defendant is alleged to have participated in a robbery and have punched the complaining witness and have taken $240 from that victim, in which the victim suffered injuries to his left eye. The state believes this defendant does pose a significant threat or danger to any person, to the community, and a significant risk of intimidating witnesses or otherwise obstructing the administration of justice. The state is aware of the defendant's lack of a criminal history. However, the state believes that a stay away, no contact for that named complainant, no contact with any other co-defendants, and ankle monitoring and any other conditions that you deem appropriate would be sufficient in this case.
Judge, I could respond.
Hold on, Ms. Taylor. Give me a number, Ms. Porter.
Yes, Your Honor. I previously looked at this case. Since Your Honor is asking for a number, I previously wrote down $75,000 as an appropriate bond with this case, considering the nature of the charges alleged, the injuries suffered to the victim, and the money that was taken from the victim as well.
All right.
And
What else?
If I could respond to that, Judge, there is allegedly a video. There's nothing in this video that shows my client punching anybody or taking anything from anybody. He does not know the victim in the case, Judge. Had no reason to be punching him or taking anything from him. No history of this whatsoever. A $75,000 bond is punitive in this matter. That's not a reasonable bond under these circumstances for someone in his position. He meets all the Ayala factors and is entitled to a reasonable bond. That's not reasonable, Judge.
No drugs unless prescribed, no alcohol, no weapons, no further contact with Travell, Trevelle, McCrae, McCrae. Stay away from 870 Mason Turner Road. Stay out of Fulton County unless you're here for court or to see your lawyer. You can have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, and medical. No further contact with DeAndrew, DeAndrew King. That's a co-defendant. No further contact with Dion Watts, DIONWATTS. $40,000 good bond. Don't even come to Fulton County and get gas, sir. Best of luck to you. You can leave the booth.
Judge, can he go to school or work?
Is he in school?
He was, Judge. I guess he'd have to try to re-enroll in school or go to some type of school. He's 18 years old. He needs to be in school or trying to work.
Well, I agree. Has he graduated? You didn't say. Have you graduated? No, thumbs up or thumbs down?
I said he was in the 12th grade,
right.
Judge.
He can go back to school as long as you got the name of the school and show proof that he's in school. And he's got to tell the schedule. That's when he can leave for that. Best of luck to you. Thank you.
And work, Judge?
You can talk about that with the state later. Let's get him in school. School's more important. All right. Xavier Collins. Did we take care of that one yet, or we got Mr. Hoover show up?
Yes, Your Honor. I just got here.
All right. Let's see. Position 11. Xavier Collins, 22 CP 210375, 201 days without indictment. Been in custody 201 days, aggravated battery, aggravated assault with a deadly weapon. As of July the 4th, there is no bond from.
Judge, in regards to Mr. Collins, hold on. Open case 21 CP 202583, aggravated assault with a deadly weapon, firearm during 22 CP 208-653, marijuana with the intent, trafficking scheduled trafficking, and then scheduled one or two substances with the intent to distribute firearm during firearm by. Convictions, theft by receiving stolen property, 2012, burglary, smashing, grab, and felony theft by taking. 2 arrests for probation violations, 3 FTAs, 008, 08, and 2020. Nothing further.
All right, go ahead, Mr. Hoover.
Yes, Your Honor. In regards to Mr. Collins, the case he has the open case that you heard that deals with drugs, and I believe he already has a bond for that, and he has another attorney that's already representing on that one. I'm representing him on the one case that he has here that he does not have a bond on. It's my understanding that this happened because there was an altercation while he was at Rice Street on the other case. And during that altercation, a fight broke out with multiple people. It's my understanding that Mr. Collins was not the person that was found with the weapon. There is an actual video of it that I've heard about. In the video, Mr. Collins is not seen stabbing anybody. He's not seen giving someone a weapon. He's not seen taking a weapon and hiding from it or hiding it from everyone else. It was an altercation between a large group of people. We're still trying to figure out how many people were involved in it, Your Honor, but he was not the one stabbing anyone or anything like that. And again, because he's been in so long without having a bond for it, he is off, or he's supposed to have one, Your Honor. We're just asking for a reasonable one at this point.
All right, looks like it's been reset a few times for your appearance, but all right, what says the state?
Yes, Your Honor. Your Honor, this defendant, as defense counsel indicated, has an open matter in which bond has already been set on that case. And this incident did occur while the defendant was incarcerated. The victim was stabbed in his head, back, and on his hand as well. Your Honor, the state believes that this defendant does pose a significant threat or danger to any person. This defendant was in pretrial custody and committed a new felony. So this defendant does pose a significant risk of committing new felonies pending trial and a risk of intimidating witnesses or otherwise obstructing the administration of justice. Your Honor, considering the defendant's open matters, the seriousness of the allegations and the warrant that this happened while he was in custody, Your Honor, even though the defendant is entitled to a bond, the state believes that with his open matters, which are also aggravated assaults and trafficking of marijuana, which also involves a firearm, 3 failures to appear, and a probation violation, he's not a good risk for bond. the state would ask for conditions being a stay away or no further violent contact with that named complainant, as we do understand that he's also incarcerated, and any other conditions that you deem appropriate to ensure the defendant's return.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Vernon Young. The other cases one has a $75,000 bond, one has a $10,000 bond. Ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, and medical. $25,000 on count one, 25,000 on count two. Best of luck to you, sir. You can lay the booth. All right, Mr. Calloway. Hold on. You ready for Mr. Calloway?
Your Honor, I am not. Is it possible to get put in a side room with Mr. Calloway? I know he's located in DeKalb County. I just recently found out. Red Street recently told me, so we haven't had enough time to actually discuss anything.
He's in Cobb.
Cobb. Yes, I'm sorry.
All right, that's okay. Do we have any breakout rooms even?
I can get that for him, for Cobb. Hold on one second.
Thank you. Where is
They may be able to put him on the phone. It may be easier.
Yeah, I guess we need to wait to the deputy to see if you can ask her. That may be easier for Cobb.
Hey, deputy, would it be easier to put him on the phone so he could speak with Mr. Hoover? Cobb? You're muted.
Yes, Your Honor.
Okay, do you have a number?
Yes, ma'am. 404-227-6572.
I'm calling right now. Thank you.
Since you're standing right here, since you're
All right, so we'll go ahead with, let's see, Mr. Banks. Mr. Banks, wave your hand. All right, Mr. Melnick, saw you earlier. There you go. All right, it's position 10, pretrial 22, CP 211363, Adderley, Dwayne Banks, 97 days without indictment, no bond as of August the 11th, possession of controlled substance schedule 2 with intent to distribute, possession of controlled substance schedule 3, 4, 5 with intent to distribute, possession of firearm by a convicted felon, and a possession of marijuana with intent to distribute. That's 200 oxy, 11 pounds of marijuana, and 100 Xanax. Trial.
Judge, 13 prior arrests, open case, 20 CP 210-142, trafficking in illegal drugs, marijuana with intent, schedule 1 or 2 with intent, 2 counts, excuse me, schedule 2 with the intent, firearm by. He's out on a $90,000 bond on that case. He's on probation for firearm by, sentence in 2020. 3-year sentence. Other convictions are firearm during, firearm by, controlled substance, ultra ID mark, cocaine with the intent, and firearm by a convicted felon. Nothing further.
Mr. Melnick?
Thank you, Your Honor. Good evening. Your Honor, Mr. Banks is 35 years of age. He will be living in Ellenwood, Georgia, which is in DeKalb County. And I'm get that address here in just a second. It is 101 Solomon Drive, Ellenwood, Georgia, 30294. He is gainfully employed. He works at the Peter Street Hair Salon, which is on Peter Street in the West End. He has, all of his family lives in Atlanta. He has 2 minor children, ages 12 and 6, that are dependent upon him for support. Your Honor, what he tells me is that he was in an apartment complex when the police pulled up and detained him and found drugs in another location, but assumed the drugs were his and placed that on him. He did not have the gun nor the drugs in his actual possession at the time. Your Honor, when pretrial read off his record, I had looked at something here and I wanted to make sure that we have it right, because I actually do not think that he is currently on active probation. He was given a probated sentence in 2020 in Fulton County, 20 SC 174334. And when he was arrested, they initially put a probation warrant on him, but that probation warrant has subsequently been rescinded. And I'm looking at it right now. His probated sentence has expired. It was a 3-year probation sentence, and that has already expired. He had already spent some time in jail before he got sentenced. In any event, Your Honor, he has very strong ties to the community, and these are non-violent offenses, and I would ask that bond be set accordingly. What I'm asking you to do is set a $10,000 bond on each of the possession with intent charges. The possession of Schedule 1 or 2, 10,000. Possession 3, 4, and 5 with intent, 10,000. 20,000 on the firearm, and 5,000 on the marijuana.
What says the state?
Yes, Your Honor. This defendant does have open matters, as Madam Pretrial Services indicated. They involve drug-related offenses, which mirror the charges before the court. And he has drug-related convictions, possession of cocaine, 2 convictions from 2008. He also has prior convictions of possessing a firearm. He's a convicted felon, and now before the court with the same charge. For that reason, the state believes that this defendant does pose a significant risk of committing new felonies pending trial, as he has open matters. He's out on a $90,000 bond, and now he's before the court. Your Honor, I know that you do ask for numbers. The state believes that a bond should be no less than $90,000, considering that he's already out on that matter, and now he's with new charges related or similar to that matter in which he's out on bond. Your Honor, the state would also ask for conditions being no drugs, ankle monitoring, 24-hour curfew, and any other conditions that you deem appropriate.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 455 Fulton Street Southwest. Stay out of Fulton County unless you're here for court or to see your lawyer. Don't even get gas in Fulton County, what I like to say. You got a 24-hour curfew. You can see for court, lawyer, and medical. No further contact with your co-defendant, Jamaica Jackson. Ankle monitor be paid for by the county. See, yeah, I think the other offense, Mr. Maddox, was committed June 24th, and the incident June 24, 2022, and this is August the 10th, 2022. All right, so 40 on count 1, 40 on count 2, 15 on count 3, and 20 on count 4. 40, 40, 15, and 20. And that's it. Best of luck to you, sir.
Thank you, Judge.
Let's see. You have another one there, or are you done? Is that it, Mr. Melvin?
That's
all right.
Thank you.
All right, have a good evening. All right, let's see. What about Jermaine Watts? It's Watts, wave your hand. Okay, there we go. Who's here for Jermaine Watts?
Renee Roberts, Your Honor, on behalf.
Oh, gotcha.
Ms. Roberts, did you still need?
Yep.
Or you want to go forward?
Yeah, if I can have a couple minutes with him. Yes.
She can put you in a breakout room. Let's see. So, doing that, we can maybe address a couple of these. Ms. Rockwell said she wanted to go last. Let's see. What about we address a couple of these bond modifications? Is that okay? Ms. Robinson?
Yes, ma'am, Your Honor.
All right. Let's see. Position 1 on the add-on calendar. It's Alexis Martinez Blanco.
Good evening, Your Honor. Aaron Donalek for Mr. Martinez. We're here on that case. We also have a consent with the prosecutor.
Okay, you can on this? On this?
Yes.
Okay, you can email it to me and I'll sign it.
Okay. Thank you, Your Honor. May I
yes, go ahead. Yeah, and you can leave too, Mr. Martinez. All right, what about position 2? Shakuria Shanquil Bigby?
Alicia Taylor for the state, Your Honor. I'm not sure who the attorney is on the case.
It says that David Jones.
Yeah, I've never spoken with anyone.
Let's see.
Judge, he was emailed that information.
All right, let's see. Is Mr. Bigby here? I don't see him, so I guess we could just skip over that.
Your Honor, since no one has appeared for that motion, can the state request that that motion be denied?
It says David Jones. They were sent it. Yeah, I mean, neither one of them appeared, so we'll just say denied.
Thank you, Your Honor.
All right. For their failure to appear. All right, let's see, Ms. Wells. We got Russell Allen Nelson, 22 CP 207753. I know you're going to waive sounding. This is a bond modification. There's a $250,000 good bond. Anything free trial?
No, Judge.
All right, go ahead, Ms. Wells.
Yes, Your Honor, this gentleman has nothing in his history. He has paid a very, very high bond of $250,000. He was accused of possessing child pornography. He's 70.
For waiving.
I'm sorry.
We were trying to waive sounding for you, but.
Trying to what? I'm sorry, Your Honor.
We were trying to waive sounding for his safety, but.
Yeah.
Waive sounding of the charges, but go ahead. Is he here? Where's he at?
Yeah, I had actually emailed ahead of time and I said, you
I'll
know.
talk to you later.
Go ahead, I'm sorry. Okay, well, go ahead with your bond argument.
Your Honor, yes. So he's 75 years old. He lives in Fulton County. Like I said, he's paid a very, very, very large bond. He had to make payments on that. He's 75 years old. He's retired. He's on a fixed income. But he made the bond, but he's on an ankle monitor, which he pays for on his own on a limited income. He has nothing in his past. He has health issues, which he has to go to the doctor for, dermatology issues, MRIs from time to time. Last year he had a heart monitor. This is rubbing his skin completely raw on his ankle. And frankly, Your Honor, I hear these other cases with these other charges. They're violent crimes, robberies, assaults, etc. What he has is completely unrelated to having an ankle monitor. I certainly understand that they, want to reduce him to a tier 2, but from what I understand, my paralegal and I have inquired, and she spoke with someone who was very, very professional, helpful, and said that frankly he's not even being monitored, Your Honor. That and that they did suggest, even someone in pretrial had suggested that only level 3 offenders that he really should be removed have this ankle monitor removed, that we should ask for that and ask him to be monitored by pretrial as a level 2 offender. He is clearly not a flight risk. He's been here all of his life. He's worked here. He has, he's paid a very large bond, as I said. He has a wife here. He wants to be able to travel to his children for the holidays. He was arrested in March. Here we are in November, almost 8 months later. This hasn't been indicted. There's no allegation whatsoever that he's ever approached anybody or ever contacted anybody at all. And the ankle monitor is supposed to serve it serves a purpose, not to be punitive. So we're asking, it just makes no sense that he has to pay so much for that. It's rubbing his skin raw at his age. It doesn't make any sense. And it doesn't make any sense with his charges, frankly, Your Honor.
All right. It's who's my prosecutor?
Your Honor, Ms. Taylor again.
Okay, go ahead, Ms. Taylor.
Your Honor, the state is asking that the bond conditions remain the same. I hear Ms. Attorney Wells' argument. However, our concern is the nature of the charges. There were over 6,000 images found in Mr. Nelson's possession. Without going into the facts of the case, we all know what the charges are. It's standard practice to have ankle monitors for a case like this, just to assure appearances in court and to give incentive to continue on in the case without disappearing. We need to know his whereabouts. Though, as Ms. Wells stated, he has not contacted anyone. She also alluded to the fact that others wearing the ankle monitor are accused of a violent crime. I mean, I beg to differ. This crime is one that is pretty egregious. And the sheer number of images on his computer and other devices show that he is a danger to the community. It may not be seen as a personal crime at this time, in that he did not necessarily speak with someone, but it's often a gateway crime to who knows what could happen in the future. Based on that, we'd ask that those conditions remain the same. Furthermore, the state does have plans to have that case indicted by the end of the month. As Ms. Wells stated, it was a case that came about early in 2022. It's not as if, like several others, it's been pending for several years. We have gathered most of the information that we need. And again, it should be indicted by the end of the month with additional charges added other than the one that he's accused of.
So, I mean, I didn't set this because there would have been a lot more detail to the restrictions. I think Ms. Wells knows that. So, I mean, has there been any violations? I mean, I'll definitely make it paid for by the county, but I was talking with a couple of the other judges. We're at a point where, 10 months to a year on this with no, violations is, and you haven't indicted on this, getting a little overkill.
Your Honor, if I may, I don't know if there have been violations or not. There's not anyone from the ankle monitoring company present in court today to state whether or not there have been no violations. It is going to be indicted this month, but obviously it's in the discretion of the court, Your Honor.
What did you say, Ms. Wells?
Your Honor, first of all, again, this is not supposed to be punitive. She wants to assure appearances that he will appear in court. Their pretrial should know whether he's violated. And this is, they're on this call, and we have been told that he is not being monitored anyway by pretrial. So that just completely defeats the purpose. Second of all, assure appearances. He has a $250,000 bond. He's hired me. He's 75 years old. He has no priors. He's didn't put an ankle monitor on every single person. I mean, yes, these are serious charges. I get it. And I know that the state doesn't like the charges, but again, we don't know if those 6,000 images are due to a video that they've counted each image. We've waited 8 months. We have no information, and I'm perfectly willing to hear what else they want to talk about. But, honestly, Your Honor, no matter what they're going to add on, he's not been accused of rape. He's not been accused of assaulting anybody. He's not been accused of touching anybody. An ankle monitor, he's been accused of having something on his computer. What does an ankle monitor do to assure that he's not going to get back on his computer? The only thing they want to do is make sure he shows up in court. That's what a bond is for. And so, Your Honor, I'm asking, due to his age, due to his lack of criminal history, that this ankle monitor come off him. It just makes no sense. And in fact, it's punitive.
Your Honor, I would further state that his age should have nothing to do with it, nor should the fact that he doesn't have any criminal history. Cases like this, there often is no criminal history, and the age is irrelevant.
All right, to tell you what we'll do, since I said that right now, Ms. Wells, what we'll do is Ms. Robinson, is our last night, is that a private night or is that public defender night, the 15th?
The 15th is, I think that's a private night. I'm sorry, public defender. February, are you talking about December 15th?
Right, the last night for
Thursday, that's a PD night.
Ms. Wells, here's what I'm thinking. They say by the end of the month, why don't we squeeze her, go ahead and make it, change it that's paid for by the county, just add her to the 15th, and you've had time to indict him. If not, he's been that long, he shouldn't have to. And Ms. Wells, I wish you'd have came in sooner. That's what the work of money's for, people that can't afford it.
Your Honor, let me ask you also too, there is a smartwatch that is used by Second Chance Monitoring, which is in Fulton County. That would be easier if he's going to have to be on some sort of monitor for him to have the smartwatch. It's, I mean, yeah, age is a factor, Your Honor. I disagree with the prosecutor and his lack of criminal history. That's the first thing everybody always asks for. Is there criminal history? It does make a difference. Otherwise, it wouldn't come up in every single case. So I just don't agree with the prosecutor on that one.
Does, do they, I mean, see, for them to be able to be paid for by the county, it's got to have, they have a vendor, because that's what the ORCA money's for, overcrowding, et cetera, et cetera. So is that a vendor? Do y'all know with Fulton County? What do we find out, Ms. Robinson, on those other folks?
On which folks, I'm sorry.
Oh, that we met with the other day. Do you know, Ms. Francis? Oh, Ms. Gass is not on here. How much is that, Ms. Wells? Because I don't know if I could order it to be paid for by the county if they're not a vendor.
I do know that it is something that, frankly, I know that it's something that, you know, Second Chance is a bonding company that Fulton is right there in Fulton, and that is who he has his bond through. And I do know that, frankly, Cobb is now using this, but as far as money and all of that, I really don't know, because, you know, when your client can either get out of jail and be on a monitor or be on some sort of monitor, they would sacrifice anything to be out of jail. So I've never really asked. It's just that, you know, my clients, you try their best to figure it out if they can. I didn't really know I needed to know that. So honestly, I just don't know right now. But I can find that out. But it just makes a.
I met with some people the other day, and I forget what it's called. Teletrix, something like that. It's something that some people are doing. So what we'll do is it's a month. He'll have to pay for it. I think they said when they met with some of us that it was $4 or $7 a month. Don't quote me on that, but they can put it on him if he goes by the jail. They have them there. We looked at them, and then just put her back on the 15th. And it's a watch with it looked pretty cool. They can set
It's cheaper. Judge, they say it's cheaper than the ankle monitor. That's what some prosecutor told me.
Yeah. I don't know who's not approved and who's not approved, but that's the only thing as well. I don't know who, I would say, but I don't know if they're a vendor yet. So I don't know if I can say that, but if it's cheaper, it's just another month. So you can put in there that they can switch to the, what is it called? It starts with a T.
Secure smartwatch? Oh, goodness.
It's called Teletrix.
Okay, there you go, Teletrix.
Thank you.
But like I said, I don't know if they're I don't know who you would get in touch with to, let's see. Let me put a phone number in the chat for you, Ms. Wells. And these are the people that came to talk with me. So I want to see, because I was told that maybe they did not have a vendor number. So some people are supposed to find out for me, but let me put the phone number in the chat for these folks. And that way you can figure out who he needs to meet to get it put on. Let's see.
But Your Honor,
Okay, there, you got that?
And let's see here. I do. Thank you so much,
Okay.
Your Honor.
So
Your Honor.
call them and they can tell you. They call them and they can tell you. And then we'll so you can switch it to that. He can pay for it. I think it's supposed to be cheaper. It's on his arms. Kind of looks like looks a little bit bigger than a smartwatch. But anyway, he can do that. Okay.
Okay, and Your Honor, I mean, my first choice would be that he has no monitor at all, that he'll just come to court when necessary. But if obviously that would be the second choice. So are we did you say we're gonna reconvene on the 15th?
Yeah, I mean, she said they were going to indict it by the end of the month. So.
Okay, so I'll be sent that a new Zoom link for the 15th. So
I think it'll probably be I think it's probably the same link, but yeah, if the link changes, we'll send it to you. Right, Ms. Robinson?
Right. I'll add her case to the 15th and she'll get another email notification.
Thank you.
So, Your
Judge,
Honor,
but you did tell her in the interim.
to understand
she can
correctly, are
take
you
off
saying
the
we'll
pay.
reconvene?
Hold on. What, Bostic?
You did tell her in the interim she can change that from a paid to county paid ankle monitor, right?
Yeah, but I don't know if they're a vendor. That's the thing.
No, just the ankle monitor first. Because
Well,
she said he's paying for the ankle monitor.
Would you
You know
rather have the watch, Miss? Okay, hold on. Would you rather have the watch, Miss Wells, or the county pay for the ankle monitor?
The watch.
Okay, the watch. So she's going to pay for. He's going to pay for it. I know it's not more than this, but Miss Gaston was supposed to see if they were a vendor because it's all that, vendors and Orca and all that stuff. So call that number, talk to them, and they can switch it over. They can make sure wherever he's got to meet them or whatever has to happen happens. I think they're supposed to be watching it this evening because they were going to see how court ran. Okay. And then we'll send you the reset date for that 15th.
Judge, just so I'm clear, will Miss Wells be sending in an order for?
Yeah, just send me that order, Miss Wells. Switch to the hold. Yeah, let me see how to spell it. Dang it. That's what I was looking at. Talitrix. It may be the same. Yeah. Talitrix. Yeah, and it's. I think some of the bonding companies are using it, so it may be that. But until we figure out about them being that, I mean, it's just 1 month, and that way he can get in touch with them, or you can get in touch with them. Okay.
So we'll go ahead and submit that order to you, Judge Manning, and then
yeah, you can send it directly to me. I'll sign it and get it filed.
Okay, and then we'll still readdress whether he even needs a monitor at all on the 15th.
Right.
Okay.
So, Your Honor, to be clear, the 15th tomorrow or the December?
No, December 15th.
Okay, thank you.
That's our last night for the year. Then we go start over in January.
Thank you, Your Honor.
Okay. All right. Thank you, ma'am. You can leave.
Thank you, Your Honor.
All right. So who
Thank
else?
you, Your Honor. Have a good evening.
Thank you, you too. So what did we decide on Jermaine Watts? Are they back?
Yes, Your Honor.
All right. Position 2 again, pretrial 22 CP 211328. Jermaine Watts, 97 days without indictment, loitering and prowling, willful destruction, theft by receiving stolen property. Pretrial.
24 prior arrests. Took the first offender on burglary in 2016, simple assault, and theft by shoplifting. 2 open case, 22 CP 212425, Arkansas, 19 SC 167493. 4 CWAC charges, kidnapping, with 5 CWAC charges assigned to Judge Lethbridge.
All right. Go ahead, Ms. Roberts.
Yes, Your Honor. My client has been in custody since August 9th, 2022, charged with loitering, obstruction, and theft by receiving stolen property. He was actually at a hotel. Someone called and said that he wasn't at the time when officers got there, he wasn't committing any crimes. As a result of seeing officers, he did run. However, Your Honor, as stated, this case has not been indicted or accused in this past 90 days. He is entitled to a reasonable bond. And Your Honor, if he's released, he will be residing at 3300 College Street in Atlanta, Georgia with his mom, Colette Baggett. He was also employed with Ashley Furniture, where he said that he has a job when he gets out. So Your Honor, we will ask for a reasonable bond on these charges.
What's the address he'll be living at?
On 3300 College Street, Atlanta, Georgia.
Okay, gotcha. All right, what says the state? It's $17,000 right now.
That's correct, Your Honor. $17,000 is a reasonable bond, considering this defendant does have open matters. As Madam Pretrial Services indicated, I believe 2 other open matters. This is his 3rd matter. $17,000 is a good bond. There's been no change in circumstances. There is a victim in this case, the 2 victims in this case, Your Honor. The state would ask for no contact stayaways, a 24-hour curfew, ankle monitor, and any other conditions that you deem appropriate. If you are inclined to reduce the bond, however, it's the state's position that $17,000 bond is appropriate, considering this defendant's significant risk of reoffending now that he has 3 open matters in Fulton County.
All right, so I got the one Kim Harris. What's the other's name? Some of these warrants I just can't read. They're horrible copies.
The first name is Willie, Willie. The last name is Conner.
All right. All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 2471 Old National Parkway. No further contact with Kim Harris, Willie Conner. 24-hour curfew except for court, lawyer, and he's got a job. Medical. And work. He has to supply the name of his employer, the schedule, and the exact location where he'll be working. As long as he supplies that to the ankle monitoring company, they'll be paid for by the county, then he can leave for work. Okay. So I'll leave count 1 at 1, count 2 at 1, and count 3, make it 10. 1, 1, and 10. And it also says stay away from all travel lodge motels. Best of luck to you, sir. You can lead the booth.
I don't know if he heard you, Your Honor.
You can lead the booth, sir. All right, let's see. Thank you, Ms. Roberts. Let's see, is Mr. Hoover back? Not yet? They're still talking? Wait, Mr. Hoover?
No, Your Honor, I'm back.
Okay. All right, you ready?
Yes, Your Honor.
All right, it's position 12, 22 CP 207-376, 19 counts. I'd rather say that. Hopefully that's okay. Of entering auto or motor vehicle with intent to commit a theft or felony therein. 258 days without indictment. Like I said, 19 counts of that, and his current bond is $475,000. I think there's other cases too. Trial.
Is this Mr. Calloway?
This is Mr. Calloway.
Yes, he has, I think, 5 other cases. For entering autos and various things, 22 CP 207, 107, 106, 109, 110, 105, 300, 188. 5 prior arrests total, nothing further.
All right. Go ahead, Mr. Hoover.
Yes, Your Honor. Now, as you've already said, he has a $475,000 bond on the 9 charges. It's my understanding that he started out with 8 or 9 charges, got the bond, and then the state started adding more. I'm not sure if they started adding more charges or if they started adding new cases. And I say that because based off of my experience, when it comes to a gang case like this, they always start out with like 8 or 9 charges. And then once the case is indicted, it's not 5 or 6 open cases. It's one case with 30 to 100 counts. It sounds like that's what's happening here. It doesn't sound like there are 5 open cases at the moment, especially since this case is, he's been arrested since March and none of these 5 open or 6 open cases have been indicted. It sounds to me like they're trying to add on more cases, which makes it a different story at this point, especially with the gang cases. It means that there are other co-defendants involved. There are other issues involved that the state hasn't shared with all of us, except for the fact that they're going to say that it's open cases. I would say at this point, Your Honor, $475,000, that's pretty much no bond for my client. We're asking for a reasonable bond on this point. It wouldn't surprise me if the state comes back, doesn't indict it by the end of the year, and there's 20 more counts added onto it. And that's just based off my experience alone. Unless the state can give us the date of when this will be indicted so we can move forward, I'm asking for at least at the most a $200,000 bond on this, Your Honor.
All right, so he's got one case that has 2 entering autos, one that has criminal trespass, damage to property, entering auto, one that has hijacking a motor vehicle. There's another one, aggravated assault, possession of firearm, gang charge, another aggravated assault, possession of firearm, gang charge, armed robbery, then a gang charge in possession of firearm during the commission of a felony, then ag assault, then all of these. Yeah, and then there's a theft by receiving stolen property. So what's that in the state?
Yes, Your Honor. Just to bring some more information, the first case was filed, which is 105, ending in CP number 105, was filed on March 2nd of this year. And then there were 5 other cases that were filed the next day, and then another case that was filed on March 4th, and then this the matter before the court was filed on March 11th. So that's a 9-day investigation in which the state was able to present these charges. So it's not something that was punitive or things of that nature. It appears to be an investigation. However, I'm not the assigned ADA to that case. As it pertains to the warrant before the court, there are 19 counts, Your Honor. It appears there's $25,000 for each count. That appears to be reasonable, considering the number of victims involved in this case. Several different victims, several different vehicles that were damaged and or items were taken from them. Your Honor, he also, with the number of cases that he has open, this defendant does pose a significant risk of committing new felonies pending trial. There's also a risk of intimidating witnesses. There's a great number of them. I think I stopped counting at 12. Your Honor, the state is actually for a no contact stay away from those named complainants, and we believe that a reasonable bond is already set as it's $25,000 per count. And if Your Honor is inclined to to decrease the amount, the state would ask for you to add ankle monitoring and a 24-hour curfew and any other conditions that you deem appropriate.
All right, let's see. Ms. Holmes, if you look at the old bond conditions, the old bond order, and that'll give the list of all these, but all right, no further contact with Lucius Weaver, Dylan Green, Daniel Toller, Julius Appling, Sean Simmons, Andrew Adjett, Wesley Bowles, Shaquina Williams, Valencia Bridges, Theodore Pearson III, Gregory Griffith, Tavares Barber, Jarrell Thornton, Andre Coles, Denise Sims, Courtney Strong, Thalius Amy, Jalon Cooper, Andrea Gendria, Alec Aleik Garlington, Eric Rodriguez, Brad Sims, and OMOYE MWEN, last name ENABULE. He cannot stay at the address 320 Fairburn Road in Atlanta, Georgia. Must provide a new address, no weapons, no drugs, no firearms, no associations with any gang members, PFK or Goodfellas, no drugs without a prescription, no alcohol, 24-hour curfew except for court, medical, and school or attorney visits, no social media, no electronic tablet because they had those there, no contact, no calling gang members. So there shouldn't have been any calls because I set this back on June 2nd, 2022. Stay away from 1100 Fulton Industrial Boulevard. And I didn't, let's see, and that'd be a 24-hour curfew. Is his address in Fulton County?
Your Honor, he has a sister that's in Fulton County and a cousin that is outside of Fulton. So he can provide either of those, whichever works for the court.
All right, he can stay out of Fulton County except for court, see his lawyer. Like I said, don't even get gas in Fulton County. So what I'll do is he's got those other cases. I don't know how in the world he's going to make all this, if it's even possible. So we'll reduce all these to 15,000 each.
Thank you, Your Honor.
Thank you. Best of luck to you, sir. You can lay the booth.
Your Honor, that concludes my business. May I be excused?
Yes, ma'am. And you too, Mr. Hoover. I think the last one is Miss Rockwell.
All right. Thank you, Your Honor.
All right. Are you Lee Forehand?
Judge, you also have one, I think, still Derek Turner on the add-on calendar.
Oh, I've got, yeah, but I'm talking about in custody. Yeah, right. Is that, are you Lee Forehand? You gotta give me a thumbs up or something. Okay, got you. All right, position 9. 22 CP 211413, Lee A. Forehand, 96 days out of indictment, got aggravated assault with a deadly weapon, possession of a firearm or a knife during the commission of or attempt to commit certain felonies, possession, manufacture, distribution, sale of marijuana, that was 144 grams, and criminal attempt to commit murder, felony. Trial, no bond as of 8/12.
No prior arrest.
All right. Go ahead, Ms. Rockwell. I got him living in, is he gonna live in Atlanta or is he gonna live in Jonesboro?
Judge, I've got his mom on the phone right now, and I would like to tell you a little bit about him, and then I'll call her as a witness, just so I can speed through it. First of all, he's 27 years of age, born in Atlanta, went to South Atlanta High, did graduate. He was employed. He was a security guard, and his mother will make a bond for him, but would like to have a plan. My understanding is that he does not have, well, I'll let pretrial and the prosecutor tell you about his record, because I'm limited. I'm depending on the family to tell me, but I understand that he may not have a record. His mother wants him to go to Ridgeview for an evaluation. She wants him to be there. He does have insurance. He has Kaiser insurance. And should we address her right now? Would you like to hear more about his record?
No, I mean, pretrial said no record. I'm just waiting on the Ayala factors, where he's going to be living, how's the community.
Well, he was born in Atlanta, went to high school in Atlanta. He is not married. He does not have any children. But I asked everybody to get off the Zoom link except for his mother, but because he's got a big family. I think what's important, Judge, and he will eventually be living with his mother. And may I place her under oath?
Okay, go ahead.
Madam, please raise your right hand. Do you solemnly swear or affirm that testimony you're going to give in this matter be the truth, the whole truth, nothing but the truth, so help you God? Can you state you?
I didn't see anybody raise their hand. I don't see anybody taking themselves off mute.
And I'm.
All right, so go ahead. I guess whoever's not here. Go ahead.
Okay. Okay, the first time for everybody on this. Okay, I see. Hey, Miss Abercrombie, could could you be still? Because you're gonna make me dizzy.
Okay.
Could you state your full name, please, for the record?
Is that who you swore in? That's his mother, that's who you swore in?
Raise your right hand. Do you solemnly swear or affirm that testimony you can give in this matter be the truth, the whole truth, nothing but the truth, so help you God, or do you so affirm?
Yes, I do.
State, you can put your hand down. State your full name, please, for the record.
Tamara Abercrombie.
Have you and I been in discussion regarding the release of Lee Forehand Jr.?
Yes, we have.
Okay, and because of that, have you contacted me and telling me that you did not want him to come straight home, that you wanted him to go to Ridgeview for an evaluation?
That's correct.
I'm sorry, I'm leading, Judge. I'm just trying to, it's late. Have you, as a matter of fact, identified and spoken with and made a plan with and for placement for Mr. Forehand for that Ridgeview stay?
Yes.
What did they tell you, madam, regarding the availability for a bed?
They said that it was the evaluation has to be done first, that they did not work directly with the jail, but he could come for the evaluation whenever he was released 24/7. They are available for him to come in for that evaluation.
Are you asking the court to make part of the bond order that he is not to be released to anybody but yourself?
Correct.
Is there anybody else that you would I mean, there's nobody else that you want him to be?
Yeah, his uncle would be my backup. He was on the Zoom call as well. Fulton Forehand Jr. He's my support, support. He has a big support system, but far as getting this stuff done, he would be,
Could you tell me, could you spell his name, please, for the court reporter or the record?
Fulton is Felton, and Forehand, he's also a junior.
Okay, and that is his Lee Forehand's brother. Lee Forehand's father's brother, correct? His uncle on his father's side. Okay.
Correct.
And have you made sure that his insurance is going to be able to cover everything?
Yes, I have.
Okay. I discussed with you regarding whether or not you have a home and some lots to put up for his bond. Is that something that you are planning to do?
Yes, if I have to.
Okay. And would he be willing after any Ridgeview stay? Could you please tell the court where he's going to be living thereafter?
He'll,
Give them
once
your
we get him back stable, he could come with me, or he'll have his own apartment as well.
Okay, and would you please give the court your address, because I know that there's no apartment now. Y'all have moved him out of the apartment.
Yes, that's correct.
Could
My
I have-
address is 715 Waveland Avenue, Atlanta, Georgia, 30349.
Spell that for the court reporter.
WAVELAND, and then Avenue.
Okay. Judge, she's under oath in the event that the state needs to ask her any questions.
Ms. Porter?
I don't have any questions, Your Honor.
All right, did anybody want to make bond argument? That's what I'm kind of waiting on.
Judge, for the record, and the reason I asked about her property, I think it's more important for I don't know about the amount of the bond, but that we have a plan for him, because she does not want him to for the doors to just swing wide open. I would ask the court to consider setting a bond with an aggregate amount of $50,000 distributed over the amounts. No firearms, no drugs without a prescription, obviously no contact with the victim, no return to the stay away from the incident scene, and also no further violations of the law, and to follow any and all directives after there's the evaluation and any medication, etc., that needs to be given to keep him obviously in a position not to have any further violations of the law. And anything else, obviously an ankle monitor. I would ask that initially it's a 24-hour curfew unless to attend medical, legal visits, and anything else the state would find that would give some kind of level of assurance that there's not going to be any more problems or any further violations of the law.
Ms. Porter, have you heard from the victim that was shot in the leg?
No, Your Honor, we did not reach that victim today. A victim locate was initiated and an investigator will be signed. The state believes that notwithstanding the defendant's lack of criminal history, and I was able to hear Attorney Rockwell's questioning to the defendant's mother. However, the state does believe that, you know, he is entitled to a bond, but he does pose a significant threat or danger to any person, to the community. In this particular case, there's multiple witnesses that observed the defendant and the victims, in which the victim was laying down on the ground begging for help, in which the defendant stood over him and shot him once in the leg. That firearm was recovered from the defendant's waistband, and 144 grams of marijuana was recovered from the defendant's book bag. So there's, aggravated assault, marijuana, as well as a firearm involved in this matter. So there is just a significant risk of threat or danger to the community. With that being said, the state does believe that the conditions that Attorney Rockwell indicated are appropriate, as well as any other conditions that you deem appropriate.
Yeah, what about some numbers?
Judge, I gave my numbers. I asked the court to distribute 50,000.
Waiting on numbers from the state. I like numbers.
Okay, yes, Your Honor. One moment. It is quite difficult to give numbers in a case like this. However, I am equipped to provide that number. As far as count number one, Your Honor, $50,000. Count two, $15,000. Count three, $25,000, and counts 1, 2, 3, 4. Count four. My apologies, Your Honor. I believe I gave 4 counts, if I'm not already. Oh, for the sale of marijuana, Your Honor, $20,000.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Keandre, Keondre Jones. Ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical, or rehab. Stay away from 1783 Johnson Road Northwest. $25 on count 1, 10 on count 2, 20 on count 3, and 30 on count 4. 25, 10, 20, and 30. Best of luck to you, sir. You can lay the boots. Thank you, Ms. Rockwell.
Thank you, Judge. May I be excused?
Yes, ma'am. All right, Derek Turner and Mr. Cooper.
Good evening, Judge.
Good evening. Sorry about that. I think this is the last one.
Oh, no problem.
All right, pretrial. It's number 4, 22 CP 206704. Derek Turner, possession of methamphetamine, trafficking cocaine, possession of marijuana with intent to distribute, VGCSA Schedule 2 or 4 with 2, 3, 4, or 5 controlled substance with intent to distribute, possession of controlled substance Schedule 1 or 2 with intent to distribute, possession of controlled substance Schedule 1 or 2 with intent to distribute, and possession of controlled substance in 3, 4, or 5 with intent to distribute. There's a $140,000 good bond. Trial.
Nothing to add.
You just don't have a lot to say tonight, pretrial. Go ahead, Mr. Cooper.
Yes, Judge. Mr. Turner's been out for about 4 months on this bond. In that time, he has gotten a promotion, essentially. He is now working for WLM Contracting, and he is working there as an assistant superintendent. That new job responsibility has him potentially being assigned to supervise work sites across the state, and then also potentially to go to the supply houses to get supplies and tools and stuff that they would need to do those projects. So he continues to reside with his parents in Canton, but now he does have the additional potential of having work obligations that would bring him into Fulton County. In the 4 months he's been out, I've sent 15, 20 or so emails over to now Ms. Davenport to let the DA's office know of all the different work assignments that he gets and where he's going. And all that's working out fine, I guess, for the time being. But we would be asking for him to be allowed to continue his work, going to Fulton County if required. And figured while we're here, might as well just go ahead and ask for that ankle monitor requirement to go away. But really, this is about work obligations, potentially bringing him into Fulton.
Ms. Porter?
Your Honor, the state would oppose removal of the ankle monitor and would defer to the court as it pertains to whether or not the defendant can re-enter Fulton County for work. I reviewed the warrant. There's different types of narcotics, and the quantities are very large. The bond has been set for about 4 months, Your Honor. I don't believe that it's appropriate to take him off the ankle monitor, but I will defer to you as far as the Fulton County travel for work purposes.
Well, don't defer to me. What does the state think?
Well, the state will believe that he needs to stay out of the Fulton County. I know that's, you usually add that to your cases when individuals do not live within Fulton County. The state will believe that the court was right when you made that judgment 4 months ago. So I believe that this bond is reasonable. It should not be disturbed.
And Judge, we're happy to maintain the stay away from the incident location provision on there, whatever distance that may be. That's a house that was being rented by several people that nobody has any claim to anymore. He has no reason to be anywhere around there unless WLM wants to demolish the place and rebuild it or something. But he would have no reason to be around there. But for the rest of the county, given his employment now, if they tell him, hey, you got to go to this location, it could put him in a very awkward position to say, no, how about I go somewhere in Clayton or DeKalb? So Judge,
he needs to go in Fulton County?
I'm sorry?
Where is it that he would need to go in Fulton County?
Wherever WLM tells him to go. So it's more of a precautionary thing trying to change this. because we don't know. I mean, as I've been sending the emails out as he gets the work assignments, it's, hey, he's going to be at this location doing work here. And it just kind of comes up as they come up, kind of same morning even, have to be out there at 2 a.m. to oversee concrete being poured somewhere. So Mr. Turner will text me. When I get the text, I'll shoot the email over to Ms. Davenport with the DA's office to let them know about everything that's going on. We just want to get that, stay out of Fulton County restriction lifted to, allow him to, go to a work site if WLM tells him that he needs to go there, or needs to go to a supply house there. So we're happy to leave the condition to, I believe that the bond is worded right now to allow him to travel into Fulton County, stay away from Fulton County except for court, medical, and attorney visits. I would propose just adding on there or work obligations. So, again, he's going to be residing in Canton. There's no real reason for him to be coming here again, gas or groceries or whatever. But if we're—
You don't need to get gas in Fulton County.
What's that?
No gas in Fulton County.
Right. I'm sure it's cheaper in Canton anyway.
That's sure.
But regardless, Judge, just for the work obligations, we just don't want to have him potentially mess up this great career path that he's on, this good opportunity that he has as, superintendent now at WLM. So, Judge, we would just be asking for that one minor modification.
Is he paying for it, or is
the ankle monitor?
Yeah.
That's a county funded.
I don't know if those other people are vendors, or I'd switch it. All right, he can only come here for work. I mean, but he has to give advance notice. So you got to alert the bank of monitoring company and the DA when you're going to be here, where you're going to be here, how long you're going to be here. Straight to the work site, straight home. Don't get gas. Don't pass go. Don't collect $200.
All right, Judge. So we'll just kind of continue what we've been doing. As soon as he gets one of those work assignments, we'd email everybody and let them know he'll be at this address from this time to that time.
Right. You got to let the ankle monitoring company know, and then whoever the prosecutor, I don't know, who have you been letting know so far?
It's been Rashandra Davenport. After
Okay.
Tom White sent me to her.
Okay. Then same people, just let them know. And but I would definitely let them know, the ankle monitor company, know where they're going to have him violating coming to Fulton County.
All right, Judge, and I will submit that proposed order modifying bond. Just send it via email as Word document, PDF.
Yeah, you can just send it to me.
Just send it to you.
Yeah, that's fine.
Okay.
All right, let's see. So we had this Camonte Jones, but that's still David Jones also, isn't it? Thank you. Y'all both late.
Oh, thank you, Judge. That's a different.
Judge, did you want me to try to reach out to him? I did email him and give him another reset date. Because those cases were sent from magistrate court for us to hear.
Okay, yeah, if you want to try to reach out to him really quickly.
Okay, I mean, not today. I was just saying for another day.
Yeah.
And try to have him reset instead of him having to just not. So what I'll do is I'll reach out to him and just reset those two.
Okay.
I think he had he had another position on the calendar as well.
5 and 2.
Yeah. 2 and 5, and then see if I can reset them and just tell him what the date was going to be.
Right. And I mean, I think there's only one other private attorney calendar date.
Right. And I'll just give him what we have available and just tell him, but I'll reach out to him tomorrow so I can reset those.
All right. Anything else from the prosecutor?
No, Your Honor.
I don't know. Who is David? Who's this David on here? I don't know who that is.
That's me, Judge. Sorry.
No, that says David. L-O-G-U-E, yeah. They don't work for us. All right. And I'll stop the stream and you can leave the meetings.
Have a good one, y'all.